What if I told you that the future of hundreds of thousands of international workers in the UK could be decided not by petitions, not by political debates, not by trending hashtags, but by a single courtroom battle in the High Court? Right now, 8,000 international workers have done something unprecedented. They didn't just sign a petition. They didn't just write to their MPs. They didn't just complain on social media. They raised £25,000, hired one of the most powerful immigration law firms in the United Kingdom, instructed a King's Counsel, and launched a full judicial review against the government. And this could change everything. Welcome back to GoUKGo. If you care about UK immigration policy, settlement rights, or you're personally affected by the proposed ILR changes, this is one of the most important legal developments you need to understand. Let's break this down properly. First, who are we talking about? A group calling themselves the Skilled Migrant Alliance, 8,000 international workers, have collectively funded a judicial review challenging the government's proposed changes to indefinite leave to remain timelines. But here's the key. They are not trying to stop the 10-year settlement rule entirely. They know the government has the power to change settlement timelines for future applicants. That's not the core issue. What they are fighting is something far more specific and legally powerful. They are challenging the retrospective application of the new rules. In simple terms, you cannot change the rules in the middle of someone's journey. That's their argument. And it's not just emotional, it's not political, it's rooted in established legal precedent. Now let's talk about why this matters beyond petitions and parliamentary debates. A petition can create noise. An MP letter can create pressure. A debate can create headlines. But a judicial review? That can create a binding court order, and the government can ignore political pressure. They cannot ignore a high court judgment. So what exactly is a judicial review? A judicial review is when the High Court examines whether the government acted lawfully when creating or applying a policy. This is not a public vote. There's no jury. There's no popularity contest. Senior judges look at one question only. Did the government act lawfully, rationally, and fairly under established legal principles? They don't care about opinion polls. They don't care about party manifestos. They don't care whether a policy is politically popular. If the policy breaches legal principles, especially fairness and legitimate expectation, the court can force the government to reverse or modify it. And this has happened before, more than once. Let's go back to 2008. Because what happened then is almost a mirror image of what's happening now. In 2008, thousands of migrants came to the UK under the highly skilled migrant program. At the time they entered, the pathway to settlement was clear. Work for 4 years, meet the requirements, apply for indefinite leave to remain. 4 years. That was the deal. That was the promise. That was the published rule. Then the government changed it. They extended the settlement period from 4 years to 5 years. But here's the critical mistake. They tried to apply the new 5-year rule to people who were already in the UK under the original 4-year pathway. Mid-journey. Migrants challenged it. They argued, when we came here, the rules clearly stated 4 years. We structured our lives, careers, and financial decisions based on that promise. You cannot change it after we've already committed. They filed a judicial review. And they won. The court ruled that those migrants had what's called a legitimate expectation based on the original rules. The government had acted unlawfully by applying the new rule retrospectively. Thousands of migrants were protected and allowed to settle under the original 4-year pathway. That case changed immigration law. Now fast forward to today. International workers came to the UK under a 5-year settlement pathway. 5 years to ILR. That's what the rules said. That's what visa approval letters reflected. That's what sponsor guidance implied. That's what employers planned around. Now the government is proposing to extend that to 10 years. And in some sectors like care work, potentially 15 years. And crucially, they want to apply it retrospectively to people who are already here under the 5-year promise. This is where the Skilled Migrant Alliance is drawing the line. Their argument is simple and powerful. You cannot change the rules mid-journey. We had a legitimate expectation based on the 5-year pathway. Applying new rules to us retrospectively is unlawful. And They have precedent backing them. But it doesn't stop with 2008. There was also the Tier 1 general migrant case. Again, migrants faced new settlement requirements being applied to them after they had already entered under previous rules. Again, judicial review was used. And again, the courts ruled that retrospective application could be unfair. The government was forced to provide transitional protections. So this isn't symbolic protest. This isn't social media activism. This is legal warfare based on established constitutional principles. Now, let's talk about the legal team, because this part is strategic. The Skilled Migrant Alliance didn't hire random solicitors. They hired Kingsley Napley LLP, one of the most respected immigration law firms in the UK. If you follow immigration litigation in this country, you'll see their name repeatedly attached to successful challenges against the Home Office. They also instructed a senior barrister, Sonali KC. King's Counsel status is not ordinary. It's awarded to the most experienced and senior advocates in the country. These are the lawyers who argue the most complex, high-stakes cases before senior courts. That matters, because immigration litigation at this level is technical. It's nuanced. It's about constitutional principles, administrative law, proportionality, fairness, and legitimate expectation. This isn't a standard visa refusal appeal. This is a structural challenge to government policy. Now let's walk through the process. Stage 1, legal analysis. The lawyers assess whether the retrospective application breaches legal principles. Stage 2, a pre-action protocol letter is sent to the Home Office. This is a formal warning. It outlines the legal arguments and gives the government an opportunity to respond before court proceedings are issued. At this stage, the government can choose to compromise, for example, by offering transitional protections. If they refuse, the judicial review is formally filed in the High Court. Then, a judge decides whether the case is arguable enough to proceed. If it proceeds, the court examines whether the policy is lawful. Now, here's the question everyone is asking. If the judicial review is ongoing, does the new ILR rule get paused? The answer depends on something called interim relief. The lawyers can ask the court to suspend the implementation of the new rule until the case is decided. If interim relief is granted, the policy is paused. The 5-year pathway remains in place temporarily. If interim relief is refused, the policy goes live while the case continues. But here's what many people misunderstand. Even if the rule is implemented, it can still be overturned later. That's exactly what happened in 2008. The government implemented the 5-year rule. People were assessed under it. Then the court ruled it unlawful and reversed it. So implementation does not mean permanence. Now let's be realistic. What if the Skilled Migrant Alliance loses? Judicial review decisions can be appealed. First level, High Court, single judge. If they lose, they can appeal to the Court of Appeal, 3 senior judges. If they lose again, they can apply to appeal to the Supreme Court, the highest court in the UK. There have been immigration cases where migrants lost at first instance and then won at higher levels. This process can take months, sometimes over a year. The £25,000 raised so far covers initial stages. If the case escalates, additional crowdfunding will likely be required. Judicial reviews at this level are expensive. Senior barristers charge hundreds of pounds per hour. Court fees, bundles, research, preparation, hearings. This is serious litigation. But here's why optimism exists. The legal principle of legitimate expectation is strong in UK administrative law. Courts have consistently ruled that retrospective policy changes affecting settlement timelines can be unlawful when individuals relied on previous rules. The government will likely argue public interest, migration control, policy objectives, urgent reform. But courts have previously said policy goals do not automatically override fairness and legal expectation. The government always had the option to apply the new rules only to future arrivals. Choosing not to provide transitional protection is a political decision, and that's exactly what courts scrutinize. Here's another critical point. If the Skilled Migrant Alliance wins, the benefit does not apply only to the 8,000 contributors. A judicial review on policy affects everyone subject to that policy. That means hundreds of thousands of international workers could be protected, even if they never donated a single pound. This is different from individual immigration appeals. This is systemic. This is structural. This is precedent setting. But nothing is guaranteed. Different judges interpret law differently. Government lawyers will argue strongly. Immigration is an area where courts sometimes defer to executive discretion. This is a fight, not a certainty. But it is the strongest legal strategy available. And it represents something significant. International workers moving beyond petitions and into constitutional challenge. Petitions triggered debates. MP letters created political discussion. But judicial review creates binding rulings. Governments can ignore pressure. They cannot ignore court orders. So where does this leave us? 8,000 international workers, 25,000 pounds raised, Kingsley Napley LLP instructed, Senior King's Counsel engaged, judicial review filed, precedent from 2008 and Tier 1 cases supporting legitimate expectation, potential interim relief, 3-stage appeal structure if necessary, outcome affecting everyone on existing 5-year pathways. This could become the most significant immigration court case in over 15 years. Now, I want to hear from you. Do you think the court will follow the 2008 precedent? Do you think legitimate expectation will protect existing workers? Or do you believe the government's public interest argument will prevail? Drop your thoughts in the comments. If you found this breakdown valuable, hit that like button so more international workers understand what's actually happening beyond headlines. Subscribe to GoUKGo because I'll be covering every stage. Interim relief decisions, high court developments, appeal outcomes, and the government's formal ILR consultation response. And most importantly, share this video with every international worker you know. Because whether they contributed or not, if this judicial review succeeds, they benefit. This isn't just another policy announcement. This is a legal battle that could redefine settlement rights for a generation of migrants. And on this channel, we break it down clearly, professionally, and without noise. Stay informed, stay strategic, and I'll see you in the next one.